the notary were different people. Now, what you're saying that I can subpoena all of these individuals to say that how can I utilize this information in
Okay,
my lawsuit?
I don't think you need to. Okay, remember when you start subpoenaing people from out of state, you may have to cover the cost of them getting here. Does not mean a first-class ticket. That means getting their butts here, coach, whatever. Back of a wagon. I don't care. The issue being, you don't really need to. That discussion was pursuant to a forcible detainer. That's when you've lost everything. You backed into a corner, you pull out all the stops. When they start recording all this stuff and you see how fraudulent it is, there's the stare decisis, the jurisprudence, whatever you want to call it, on doing the foreclosure when you didn't really have the authority, or doing the substitution of trustee when you weren't the trustee to do the substitution. There's tons of it. Okay, that when you do a forensic examination, that's all going to be spelled out. It's great you found it on your own. Won't do you much good. Okay, there's a big difference between you doing a discovery and an expert putting his name on it, or in a case like Bill, where the expert will come in and testify. Now, what are they going to do? You put in the expert documents. They're certified, blah, 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 spells everything out. What presumption now stands? Yours. What must they do? They must rebut the presumption, or they agree to it and it stands. If they agree that what this expert says is the whole thing is fraud, they've just admitted they lost. It really is that simple. That's why I do a prefatory statement on that document, because right there, everything after that is just evidence of the fraud. But I spell it out flat out, and you'll read it on the disc on the new complaint. Just, okay, here's who really has the stuff, and maybe they have the authority to do it, but they're not the ones doing it. All of these people are doing it. Does that make sense? So you don't need to go subpoenaing people. That's when you get down to that forcible detainer, and hopefully you won't get there. Hold on for just a second. We had one right here, Patrick.
What, instead of subpoenaing the attorney who is responsible, that you add them as a third-party defendant and they don't answer?
Okay, yeah, you could. I don't want to do that. The problem you get, how many lawyers do you want to deal with?
But
Unless they have antlers on and you got the right license, I don't want to deal with any more attorneys. Think about it.
But it was done. And what I'm basically asking is, if they did not answer, did they admit?
Absolutely. Yeah, there's no discussion there. A failure to rebut, failure to answer, respond, reply, whatever you want to call it, is an admission. Absolutely. Yes.
And the judge wouldn't even look at that.
You got to figure out why. Now, there again, I'm not going to tell you that I think judges are not corrupt. I would never say that.
In Nevada, it's the worst state. So.
Well, that the issue being, why does he not have to? See, when you understand, when you look at things the way I do, and you read pleadings and cases the way that I do, instead of the way that most people do, I look at what the judge says as being secondary always. Always. This is my primary rule of court, other than hate all the bastards. My primary rule in court is it's more important what they don't say than what they do say. Always. So if he's not talking about that, why is he not talking about that? You want to know? You want to know where you screwed up? Where did she screw up? Who does the court presume was telling the truth? Did you, in the very beginning, as the law requires, say that all the signatures, you question the authenticity and validity of all signatures, and do you deny all the presumptions the court is operating under? See, and you didn't, so you agreed that the signatures were correct and the presumptions were correct. Okay, but then lawful detainer springs from something. Sure. Okay, yes, it's a separate act, indicative of the other act. The judge is just going to move the presumptions forward anyways. And there's stare decisis for that. So, yes, I think in that case, the judge is probably corrupt in a manner that he can get away with it. Okay, if you didn't rebut the presumption that the courts are being honest from the get-go, the judge is just moving that presumption forward. Am I making sense? And you've got to understand that. A lot of the mistakes being made in court are ours. Okay? That's why we've taken so long to get here. We got to go, I don't want the court to rely on that presumption. There's a lot of different ways to stop that from happening, not always inclusive of stating, I'm going to deny all presumptions. You see what I'm saying? You want to list what's going wrong here, what the bank did wrong, and that is a denial of the presumptions. Okay? We had somebody over, and then if there's no more, I think it's about, yeah, it's lunchtime. I'm sorry, I can't hear you. I can't hear you. Wait till the microphone gets back there.
When the notice of trustee sale is filed with the county recorder's office, they're giving notice. Well, the notice is mailed to the homeowner, and it's public notice that it's a notice of trustee
Yes.
sale. Okay. Would it be appropriate, as opposed to the homeowner going in, filing in all this paperwork, opposing it, by just simply re-recording that document and indicating on there, rejected
Okay,
due
guys,
to, or not?
listen, I don't want to get into that. We talked about that earlier.
Okay.
My opinion, it's not legal advice. Don't commit felonies.
So it's no response. No, I mean, don't do anything.
Don't record nothing. Don't commit felonies.
Just let them do their thing.
Don't get married. Don't jump out of planes without parachutes.
Okay.
Don't rappel 100 feet on a 50-foot rope. I've got certain rules in life. One of them would be don't commit felonies, inclusive of don't record a false document. If you don't have the authority to rebut something that another party did record, you don't undo one felony by committing another one. Two wrongs don't make a right unless you're a politician. So there's a fundamental policy in law. Those that come to court with clean hands should always succeed. Yeah, my opinion, exactly. If the other party, if their hands are dirty and yours aren't, your opportunity for success are substantially greater. I would bet all of my money, which really is, so yeah, I know, it don't matter, against your stick of gum, that if you both have clean hands, you're going to lose. I really think the only way that we're going to win these cases, and we're doing very well right now. We're doing very substantially well. A good friend of mine in the back of the room, Jay, he was out of town. He had to file some documents. His sale was going to be on the 7th. He was one of the first to do the complaint stuff, all the new stuff. He had to do the conference, the hearing, a teleconference because he was out of town. What, you filed that on like a Tuesday, and on a Thursday they moved it out 2 months or something?
Everybody else in the defendant as a defense. Okay, I represent everybody else who, on the defense. He says, I cannot speak for anybody else, but I am not the creditor. Then I say, I move this court to have them stipulate on and for the record whether they are the holder in due course. I only had to ask that once. And he questioned the defendant. He says, I cannot speak for anybody else, but I am not the holder in due course.
See?
That's
And
what it came down to. And then it was a TRO, which is temporary restraining order. That's what I was doing my telephonic conference on. And what ended up happening is I ended up losing the TRO only because they extended it out to September 7th for the foreclosure date or the sale date. And he says, I cannot grant you this because there's no emergency measures required. So I got what I wanted, but I lost that particular case. The next step would be, I'm waiting for them to reply to my amended complaint, which John helped me prepare. I'm one of his 6 people that he helps out. At this point, they haven't replied to my amended complaint. I think it's been more than 10 days at this point.
Yeah.
And I'm going to move for, declaratory judgment, or, what's it called?
Declaratory judgment, it might be default.
Default judgment, that's it. Just for lack of words.
The point being that we filed that document 2 days before the trustee sale. It was 2 days. And they moved it out 2 months because they did not want to discuss that document. They can't. But see, he had the forensic audit stuff. We were able to list certain stuff in there. That's why I say the forensic examination stuff in there, when you can list the crimes that they committed, what are they going to do? Are they going to come in there and lie and say they didn't do this? Or are they going to move to somehow dismiss the case so they win without going into it? So far, they haven't been able to answer any of this. We haven't gotten any answer. Part of this was done early on in Cindy's stuff, and they still haven't answered. What was that, 4 weeks ago? Those emails. We brought this up when we first started on this concept, this whole new concept. Emails are usually, lawyers will always respond 2 or 3 days later in the email stuff. She got an email from them. Our response wasn't very polite. I'm known for that. But that was on a Sunday, and tomorrow it's 4 weeks. Still no response in the email.